Good afternoon, everyone, and welcome to FintEdu's webinar on resolving tax disputes with the UAE Tax Dispute Resolution Committee. We understand that tax disputes can often seem very daunting, and facing TDRC, that might even feel more intimidating. And to address this fear and concern, we are thrilled to have Marwan Al-Nouriani with us today. Marwan, he is a senior tax associate at Habib Al-Mullah and Partners with extensive experience in taxation from both government and private sectors.
Thank you very much, Anu, for the introduction. Good afternoon, everybody. I hope everybody is doing well. So today we have a short but interesting topic that we often get questions about, which is the Tax Disputes Resolution Committee. And tax disputes presented, obviously, before the committee. So when it comes to tax disputes, of course, consultants and taxpayers themselves are often aware of very initial stages, right? So when we're talking about tax assessment reviews, reconsideration requests, and then it just stops. Like they would go for a reconsideration request, for example, FTA says, sorry, that's rejected. And then taxpayers like, okay, I'm going to pay. So today we're going to talk about the next stage in the Tax Dispute Resolution Committee, which is the TDRC for short. Now, before we start, very quick introduction about myself. Anu has already said that, but just to give you a very quick brief, I handle tax disputes, purely tax disputes. So I'm a tax litigator. I used to work at the Federal Tax Authority as a tax policy specialist. So I was part of the team that works on the policies. But now in my current role with Habib Al-Mullah and Partners, I work as a tax associate, handling dispute resolution specifically when it comes to tax purposes. So moving on to our topic. We have a very interesting quote by His Highness Sheikh Mohammed bin Rashid Al Maktoum, which we would love to present today. Does water stop running when it reaches a rock? Does it? Of course not. It either goes left or right and continues its way. Now, why would we present this specific quote? Because this is how we believe taxpayers should go or should act when they have a right, when they have a genuine argument, when they have a point to make and the FTA did not provide a favorable outcome, let's say when it comes to reconsideration. So is it the end? Is it a rock? Is the FTA's decision in respect of a reconsideration request the rock that you should stop at? Not necessarily. And that's why the law prescribes a coming stage, which is the TDRC. So more on the TDRC. In today's presentation, we will be discussing what is the TDRC, requirements to object to the TDRC, how would the proceedings flow, what are the potential outcomes, and finally, some judicial principles that have been set in respect of the TDRC. So let's start with what is the TDRC and let's go back to the law, right? Because that's where things happen. That's the source of all powers and everything that is granted within the tax regime is the source is the legislation. So we go to the legislation to investigate what is the Tax Disputes Resolution Committee. So Article 30 of the law states that one or more permanent committees shall be formed. So it's a committee. It's not a government entity. It's not a separate entity. It's a committee composed of 3 members. Okay, now we have different committees. Okay, we have 2 committees in Sharjah. We have several TDRC committees are there. Okay, but when it comes to which committee or what is the committee itself composed of course, they have an administrative team that will do some admin work, but the committee itself that will adjudicate objections submitted to it is composed of 3 members, chaired by a member of the Judicial Authority. So we're talking a judge, and then 2 expert members registered as tax experts. So you have legal expertise and you have technical expertise. That's why the committee is a very important and critical stage, and that's why you cannot go to the court before resorting to the TDRC. Now, how does the TDRC work? There is a cabinet decision issued in that regard. Is it available? Can I look at it? Yes, of course. If you Google cabinet decision number 23 of 2018, you'll find even an English version of it. It's available. But one thing to note, and it's a very important note, is that this cabinet decision was issued in 2018. So it is superseded by the new tax procedures law. So you might find requirements in the cabinet decision which no longer apply. So you'll need to just make sure that there is any contradictions between the cabinet decision and the new tax procedures law, the law would supersede. What does the TDRC do? It decides on objections submitted against the FTA's reconsideration decisions. That's the key function of the TDRC. You must have submitted a request for reconsideration to the FTA. You didn't get a favorable decision from the FTA, you go to the TDRC. Or alternatively, you go to point number 2, where the authority has not made a decision. And then there is a very interesting legal question here. Does the timeline stay open indefinitely? So let's say I submitted a reconsideration request. FTA has 45 business days, nothing. 60 business days, nothing. 70 business days, nothing. So what happens? Shall I assume that the FTA issued an implicit rejection on the 40th business day or the 45th business day and then consider the timeline for appealing or objecting to the TDRC to commence from that point? Or does it remain open indefinitely because the FTA did not respond? Now, that's a legal question that can be argued both ways. There is nothing at this point that is explicitly clear. So both options have pros and cons that need to be evaluated by each business. And then, of course, any other jurisdictions interested to the committee by the cabinet. So what are the requirements? I want to object to the TDRC. It's a brave step, to be honest. A lot of taxpayers would be very hesitant about going to the TDRC, even though it's okay to go to the TDRC. It's really okay to go to the TDRC. But most taxpayers would be like, FTA did not accept the reconsideration. Tax Disputes Resolution Committee is probably not going to listen to me either, so I'm just going to stop there. You don't need to stop. You can have your shot. So let's explore the requirements to object to the TDRC. Now, the first thing is you need to object within 40 business days from the date of notification of the FTA's decision. So even if the FTA's decision was issued on, say, 1 January 2024, you were notified on the 5th of January 2024. So the 40 business days legally starts from the 6th if you were notified on the 5th, right? So the 6th being the first business day. But to err on the safe side, it's always recommended to assume that the authority, the decision date, the date on the decision itself is your safest bet, right? So assume that the 40 business days commence from that date to err on the safe side. And of course, then we go back to our question on implicit decisions. Does the 40 business days kick in? Because it says from the date of being notified of the authority's decision. So does the expiry of the timeline available to the FTA constitute an implicit decision that is immediately notified to the applicant? Again, it's a gray matter. It's a gray area in the law. Practically err on the safe side, okay? But again, it depends on the pros and cons of each option to each taxpayer. Not all taxpayers will follow the same route. In fact, it's more often than not, taxpayers follow different routes when it comes to dispute resolution, depending on the facts and circumstances at hand. So then you have two instances where an objection will not be accepted by the committee. First, if you have not submitted the reconsideration request, you cannot go to the TDRC. Forget it. And if you can't go to the TDRC, you cannot go to the court. So you have to file a reconsideration request no matter what you think the FTA's views will be. Even if you think the FTA is not going to accept it, you need to file it. If you want to present your case and have an opportunity to present it before independent third parties, i.e. not the FTA, you need to first start with the FTA. Okay, and you might hear some argue that, oh, reconsideration will never listen to you. It's still the FTA that issued the decision. They will not change. That's not true. That is not true. We have significant reductions in taxes and penalties at the reconsideration stage. So it's very critical to draft your reconsideration application properly. Use consultants, use lawyers who know what to do, how to file, how to apply, what to say, what not to say, because there is a high chance to get a significant reduction even before going to the TDRC. And then, of course, you cannot go to the TDRC if you haven't paid the tax. And this is a very critical requirement. You have a lot of taxpayers who would say, I'm not going to pay the tax. I'll just object because I don't agree with the taxes. So I'm not going to pay them. No, you have to pay the taxes to object. If you don't pay the taxes, you don't get a chance to present your case in the first place. The TDRC will immediately issue a formal rejection, telling you the objection is dismissed in form due to non-payment of tax. Full stop. Case closed. You cannot appeal, of course, unless that was not true. But if you actually didn't pay the tax, then you lose your chance. And not only that, it's very important to note that you want to pay the tax liability ASAP. Reason being, if you don't pay it within 20 business days from assessments, you will accumulate late payment penalties. You don't want to go there, right? So it's always advisable to pay the tax immediately and then challenge. But start with paying the tax. You don't want to accumulate late payment penalties. And you don't want to get into risk of having your objection dismissed simply because you didn't pay the taxes. Now, how would the proceedings go? So let's say I filed an objection to the TDRC. What's next? So you start by submitting an objection memorandum in your personal capacity as a taxpayer or through a lawyer. Okay. Now, this is the first stage where lawyers can represent taxpayers. When it comes to tax assessment reviews, reconsiderations, any communication and discussions with the authority, the federal tax authority, lawyers are not officially engaged because only tax agents can represent clients. But how would lawyers go with clients at that stage? They would advise them on what to include and what not to include in their applications. They would help them review their applications, etc. But at the TDRC, lawyers appear in their own capacity. So as Habib al-Mala and partners, we would go to the TDRC and we would go and say, we are representing X client in an objection against the federal tax authority. So you submit an objection memorandum that is also known as a statement of claim or a statement of objection, which contains all the reasons why you believe that the FTA's decisions are not correct. So the second thing is you will receive a detailed response from the FTA before the TDRC, more often than not, at least. So what happens is maybe you go to reconsideration, you get a one-pager decision telling you that the reconsideration is rejected. And everybody is like, we want more reasons, we want an explanation, we want. So before the TDRC, the authority will most likely provide an extremely detailed submission where they will argue the reasons, the arguments, why they have imposed taxes, why they have imposed penalties, provide the workings, Excel sheets, attachments, everything. So before the TDRC, more often than not, that would be the first time the FTA issues or provides a very detailed memorandum explaining why they have imposed the taxes and penalties. And then what happens is it goes into an exchange of memoranda. So FTA will submit a response memorandum. They will say, no, taxpayer is not correct because 1, 2, 3, 4. You will go back and argue again, more often than not. So you'll provide arguments, explain why the FTA's responses are not correct, why the FTA misinterpreted the law, why they misunderstood the law, misapplied the law, and it goes on. Eventually, the TDRC issues its decision. Now, the timeline within which the TDRC must issue its decision is 20 business days, and then communicate its decision within a further 5 business days. Okay, so that's the expectation, at least, to put it. Now, what happens after? So TDRC, I filed an objection to the TDRC, an exchange of memoranda happened or didn't happen. What's next? Next is the outcome, of course. So there are 4 outcomes that are possible when it comes to the TDRC. Just 4 outcomes, nothing else. Okay. The first one is non-issuance and communication of a decision within 25 business days or an extended time limit if available. So basically the TDRC is silent. You don't receive a decision, 25 business days expire, nothing. The second is a full acceptance of the taxpayer's position or the taxable person's position. What does that mean? You object, you say, dear TDRC, FTA is wrong, the assessments are wrong, the penalties are wrong, cancel them all. TDRC says, you are right. All taxes canceled, or all penalties cancelled. Does it happen? Yes. Have we seen it in practice? Yes. Okay, so it does happen. Now the second, and remember that TDRC is an independent committee, okay? It's not biased towards the FTA, it's not biased towards the taxpayer, it's an independent committee. Now, of course, at the same time, the TDRC might reject your position in full. So they would be like, yeah, we understand the objection, but the objection is rejected. This could be on 2 grounds, either formal grounds or substantive grounds. Formal grounds, for example, you didn't pay the tax, you didn't file on time. Substantive is your arguments are not valid. We believe the FTA's assessments are correct. Finally, you can get a partial acceptance by the TDRC. So a partial decision is a decision that will be partly in your favor and partly in the FTA's favor. What's an example of that? A reduction in penalties due to a calculation error, for example. So let's say FTA should have issued a penalty of 1,000 dirhams and instead they issued 10,000 dirhams. So the TDRC will say, no, the penalty is correct because you did commit the violation, but it's only 1,000, not 10,000. That's a partially favorable decision, right? So it brings down the penalties from 10,000 to 1,000, but you are still subject to a penalty. Now we go into judicial principles. What has been established by the UAE Federal Supreme Court when it comes to the Tax Disputes Resolution Committee? Are there any principles that have been set? What are some interesting judgments that have been issued? So we will discuss 3 interesting judgments that have been issued. But again, it's important to note that this is not case law. It's not legally binding on the authority to apply in every case with every taxpayer. These are just principles that were established established in a specific case, but we often use them to cite that, see, this is what we believe, this is the view that the court has previously adopted. And we have some very interesting decisions that we will discuss with you. So starting with case number 199 of 2020, what happened here is there was a taxpayer who wanted to challenge items that were not within the scope of the TDRC. So for example, take an example, okay? You go to the TDRC and you say, I'm not happy with the penalties imposed on me by the FTA. And you argue that the penalties are unfair, unjust, not in line with the law, but you forget to argue the taxes. And then you go to court and you say, I want to cancel the taxes and penalties. And the court will say, sorry, you can't do that. Because, as you can see in the code here, judicial review of legality is therefore limited to, sorry, Zoom is not helping me with this one. Second, let's go it up. Okay, that's not very helpful. So in summary, I have the thing on the right. Okay, got rid of it. Okay, so judicial review of legality is therefore limited to this decision. Consequently, it is impermissible for the judiciary to go beyond this by examining reasons not included in the committee's decision. So effectively, when you go to court, you're challenging the committee's decision. That's why it's of critical importance. Before you go to the TDRC, you need to have the submission properly reviewed, properly prepared, even from early stages. Because if you didn't challenge the taxes, for example, before the reconsideration committee, you go to TDRC. TDRC is not going to listen to your arguments about taxes anymore because FTA will argue that you didn't challenge the taxes before the reconsideration committee. So then when you go to court, you're like, I want to challenge. Not going to happen. Okay. That's the first case we have. We jump on to the second case, which is case number 1498 of 2022. In this case, we had a taxpayer who had to file their objection. If I remember correctly, that was by email. Okay? What the argument was is that this should not be acceptable because it was not filed through the system. And that's where lawyers come into the picture, by the way. So you might, if you call the FTA's contact center, you tell them, can I file a manual reconsideration request? I guarantee it. They're going to tell you that's not possible. You need to file through the system. We're not going to look at anything that happens manually. But in certain instances, in very limited instances, lawyers can guide you towards certain manual submissions and tactics and strategies that will safeguard your right at a later stage. Okay, so we have this case here where it says for a taxpayer's objection to be considered as having been filed to the TDRC, it has to be filed electronically, regardless of its form. The purpose is to ascertain the taxpayer's insistence on challenging the reconsideration decision. And then it goes on and says, if the circumstances reveal that the taxpayer has taken the necessary steps in any form, insisting on a specific format or additional documentation under such conditions is both unjustified and futile. Okay, see, even though it was a manual submission, so not through the system, not through the designated portal, but it was admissible by the court. The argument was accepted by the court. Okay. Again, can you apply this to everything? You go ahead and file a manual objection? No, I tell you, there's a 99% chance that's not going to work. There are specific facts, specific circumstances, specific limited instances where certain strategies would be worth deploying. Otherwise, they would not. It's not a one-size-fits-all, basically. Then we have the final case, which is a very recent case of 726 of 2024, where the taxpayer has resorted to the TDRC, got a favorable decision, and then the FTA went to court. The FTA challenged the TDRC's objection. The TDRC's decision. Now, what happened is that the taxpayer did not settle the taxes prior to going to the TDRC. And if you remember, that's one of the reasons that warrants the TDRC to reject the objection. But what happened is that the TDRC disregarded the non-payment of tax and issued a favorable decision to the taxpayer. Taxpayer was very happy. FTA went to court. What FTA told court is that this is not right. This is not legal. And the court upheld the FTA's views, where it stated that if it is established that the taxpayer did not settle the tax due before submitting their objection to the TDRC, despite this, the committee adjudicated the objection favorably, its decision would be unlawful, as the committee should have rejected the objection. Therefore, if the FTA appeals the committee's decision to the competent court, the court should annul the decision on the grounds that the objection was not to be accepted by the committee. So no, you wouldn't be off the hook just because the TDRC issued a favorable decision. Okay? Again, facts and circumstances of each case differ and can warrant a different argument, a different result. So all of these need to be investigated carefully before arriving at conclusions. With this, we conclude our session. I thank you all for listening.